If you have been served with a restraining order, then this video is for you because I'm going to be talking about 5 tips, 5 hacks really, that you probably have not heard on how to win your restraining order court hearing. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I am also the creator of a course in how to represent yourself in your restraining order hearing. So if that is something that you are interested in, you can get your free first class in the course via the link down below in the description box. Okay, so let's jump right in. Let's talk about 5 hacks that you probably have not heard that I don't think I've ever talked about on YouTube to win your restraining order. Now, with restraining orders, number 1, especially at your first hearing date, do not give an extra copy of your documents to the petitioner because the hearing might be continued. So how this works is that generally in restraining orders in the state of California, you don't need to give the other side a copy of your evidence ahead of time. You show up at the hearing, and what will happen is that the bailiff will tell the two of you, you need to show the other side your evidence. I have cases in the Bay Area, in San Diego, in LA, and all throughout the state of California. Courts are not giving a lot of resources to restraining orders, and so they will have, maybe 20 hearings on calendar in an 8-hour day. So that doesn't give a lot of time, and so a lot of people's hearings will be continued. They will be moved to another day, which if you are the respondent already sucks. If you're not able to see your children, if you are not able to live in your home, that's already a big hardship for you. But don't make it worse by giving the other side a copy of your evidence so that they can look at it, they can really think about, especially if they're lying, they can think about how to spin it. That doesn't do you any good. Even if you did nothing wrong and you think, well, I'll just show them my evidence. Again, the problem is that they can think about a lie. They can have a witness come in and lie for them. They can come up with a way to explain something. And at restraining order hearings, how it usually works is that the bailiff will tell everyone you need to show the other side your evidence first. You don't have to have an extra copy. A lot of people do not have an extra copy with them. And it's okay if the hearing is going to go forward to have an extra copy that day. But what you don't want to do is send the other side home with a copy so that they can, pore over it. They can think about what explanation they can have or what lie they can make up or what witness they can have come and lie about you at court. It just doesn't do you any good. It would be a lot better in that situation if you simply showed them your evidence and, they still have it in their mind, but it's not going to be as easy for them to make up a lie. Number 2. If you suspect that the other side will just straight up fabricate evidence, make up evidence, delete text to make it seem like you said horrible things to them and sent 10 text messages in a row to them when the two of you were actually just having an argument and they said terrible things too. What you can do in that case is get all of your text messages ready ahead of time. You can use an app. There's one that I linked down below if you have an iPhone to just export all of your text messages. It's really easy. Number the pages and you can print them out. Maybe there are a lot of them, but you can print them out and put them in a binder. This doesn't mean that you're going to show the judge all of those text messages, or phone records would be another example, or emails. It doesn't mean that you show the judge everything. What it means is that if the other side trots out something that is a lie, they say that you called them on a particular day and show, a screenshot from their iPhone with some contact, you can rename contacts, showing that you had called, but you know that you didn't and you have a record of all of that. It would be great if you could show the judge, okay, here are my records from AT&T showing that these are all the calls that I made on that day and I did not call the petitioner. So if you have that ready and you have it organized and you can pull it out if needed, and this is not something you have to show the other side in advance, basically you're only going to show it if the other side lies about something unexpected, something new, that they come up with at the hearing. That one piece of evidence, those phone records showing that you didn't make any calls to the petitioner that day, that could be the one thing that actually saves you and causes the other side to lose all credibility in front of the judge and causes you to win the hearing. Number 3, watch the judge closely. A lot of judges will, when they come into court, they will kind of have a speech at the beginning that they give to everyone. You also might have an opportunity to observe the judge and be in front of the judge while you're waiting for your hearing to be called. Now, some judges only want you to come into the courtroom when it is time for your hearing, but lots of times you're sitting there in the gallery, like in the audience basically, and you are just waiting for your hearing to be called. Watch the judge very carefully. Show that you're paying attention. Don't be looking down at something else. Don't be creepy, but make eye contact when you can. And if the judge tells a joke, you better make sure that you are laughing and smiling, okay? When the judge comes into the courtroom and says, "Good morning," say, "Good morning, Your Honor." You might be the only one who says it if there are no attorneys in the courtroom, but if you do that, you're already leaving a positive impression on the judge. I mean, if you've ever been on the stage for anything, you can see the audience out there. There are a lot of people, but you can see everyone, and you can observe them. They might not notice. They might feel sort of anonymous because there are a lot more of them than you, but you're not anonymous. And the judge is going to be observing you carefully, because think about the judge's job. The judge has to, within a very short period of time, look at one person who's saying, "I was abused. Here's a story of how it happened." And then they have to listen to the other side telling a different story, the opposite, that there was no abuse generally. And they have to make a decision as to who to believe very, very quickly. That's a tough job, right? I mean, usually there's not going to be absolute concrete evidence. There's not going to be, video showing exactly what happened. It's going to be, at least mostly, one person's word against another's. And to make a decision like that within a very short period of time, because the judge decides at the end of the time the two of you are done talking, they are making every observation that they can. And I've seen people who do kind of the opposite of what I am suggesting here, who come into the courtroom. I don't even know necessarily if they're the petitioner or respondent, who are angry the whole time. They're angry. They have an angry face. They kind of charge into the courtroom. They're stomping. Their arms are crossed. They're angry to be there. The judge suggests that some people might want to go to mediation. They're shaking their head. No. That person is already seeming aggressive, and believe me, the judge notices. So be the opposite of that person. Don't overdo it. Again, don't be creepy. Don't be nodding like this, because that can make you seem, manipulative. But especially when the judge is telling a joke, and especially to just be paying attention, to be sitting up straight, not to be looking down, not to be annoying anyone. For sure, don't have your phone go off. That actually does go a long way with the judge. Number 4, especially for domestic violence restraining orders, make it clear to the judge that you have moved on as the respondent. Now, what the judge is looking for in a domestic violence restraining order hearing is not necessarily just if there was past abuse. The judge is looking to see if a restraining order is needed to prevent future domestic violence. So obviously, if there's past abuse, that informs their opinion. But let's say that the restraining order was continued for, God forbid, for 2 years. And in that time, you got another partner, you moved across the entire country, you have a new family now, you haven't tried to contact the petitioner at all this entire time, you have a whole new life. The restraining order is unlikely to be granted in that case because you have moved on, right? For domestic violence to occur in the future, there would have to be contact in the future. So if you've shown that that is unlikely, then that goes in your favor. Now, that was an extreme example. Generally, it's not going to be 2 years. It might be a few months, which is already difficult enough as the respondent in many cases. But one thing that I can suggest is if you do have a new partner, they're probably not a witness to any of this, right? But again, the judge is observing you. If you can bring that new partner, the two of you come in holding hands, the two of you are obviously together, then that can go a long way. And I'm not suggesting that you put this person on the stand to say that you are a good person and you're not abusive. You can be abusive to one person and not the other, right? And I don't think that that would be persuasive to the judge. But having that person there, showing that you've moved on, can cut in your favor. Number 5, if you are the respondent and the other side does not show up for the hearing, the petitioner does not show up, then ask for the restraining order to be dismissed with prejudice. With prejudice means that they cannot simply refile it, because if it's without prejudice, what can happen is that the judge dismisses the case. The petitioner maybe slept in that day or overslept, maybe had changed their mind, but then changes it again. They can simply refile the restraining order. And now you have to do this whole thing again. You have to start with the temporary restraining order again. You have to go through the entire thing again, which is not fair to you. If it is dismissed with prejudice, they cannot refile it. So how this would play out is if the petitioner doesn't show up, the judge calls the case. The judge will say, okay, it is 9:32 a.m. Petitioner is not here. Respondent is here. We haven't heard from petitioner. Case dismissed. Ask the judge with prejudice That one little phrase could save you and could cause the judge to not allow the petitioner to file a restraining order again unless they have new allegations. I hope you found this video helpful. And look, if you do have a restraining order and you need to fight against it and you're thinking about representing yourself, you can scroll through YouTube hoping to find the answers. Or you can get them all served to you on a silver platter, which is exactly what I do in the course. You can get a free class via the link down below. You literally have nothing to lose. And if you did find the video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.